Yeah. So guys, the next concept is about applicability of the Companies Act 2013. So to whom this act is going to be applicable? As you know, Companies Act 2013, it's applicable to A. For all the companies incorporated under present Companies Act or under previous company laws. So what is the meaning of this previous company laws? Companies Act 2013 and her mother is Companies Act 1956. So, whatever a company which is incorporated under Companies Act 1956, even for those companies also, Companies Act 2013 is applicable. Yes, next. Second, it's applicable to all banking companies, all insurance companies, and all electricity companies, and any other company formed or regulated by separate acts. So, didn't understand. Banking Act is a company. Banking company is a company which is regulated by Banking Regulation Act as well as RBI Act. Same way, insurance company is a company which is regulated by Insurance Act or IRDA also. And electricity company is a company governed by special act called Electricity Act. And not only these three, and any other company which has set up or which has been governed by separate acts, for those companies also Companies Act 2013 is applicable. But one small tail here, if there is any inconsistency between the Banking Act and the Companies Act, the banking company has to follow Banking Act only. Now the discussion, now the final conclusion is, for the banking company, Companies Act is applicable, except, except means companies are not applicable when, except the provisions of Companies Act are inconsistent with the provisions of the Banking Regulation Act 1949. So now the conclusion is applicable to all banking companies except the provisions which are inconsistent with the provisions of the Banking Regulation Act 1949. Same way, what you call insurance companies except to those provisions which are inconsistent with the Insurance Act. Same way, applicable to all electricity companies except the provisions which are inconsistent with the provisions of the Insurance Act or Electricity Act. So, to get the better understanding, guys, let us imagine a person having what you call wife as well, wife and a friend. So obviously, imagine the friend as like Companies Act 2013 and the wife as a separate act. So he's going to follow friend and is going to follow wife also. Whenever there is a dispute, whenever there is inconsistency between the friend and wife, to whom is going to give preference? Obviously to wife. So applicable to all these kind of special companies like banking company, insurance company, and electricity company, any other company regulated by separate acts also, except those provisions which are inconsistent with the special acts. These are about applicability of Companies Act 2013. Now next, let me extend the discussion to the different types of companies. Guys, companies are of many types based on what we call many parameters. Now, first let us see different types of companies on the basis of liability. Yeah, on the basis of liability, the companies are limited liability companies and unlimited companies. Sir, you said the features of company law or limited liability is one of the feature. Yes, so there might be companies with unlimited liability also. Unlimited liability also. So, based on the liability of members, the companies are of two types. One is limited liability company and unlimited company. And in the limited liability also again there are two types. One is limited by guarantee and limited by share capital. So the company limited by guarantee is the one where the liability of members is limited to the extent of guarantee given by them. And this guarantee amount has to be contributed only at the time of winding up or the liquidation of the company, that too in case of deficiency. So whenever there is a deficiency at the time of liquidation, the deficiency has to be contributed by the members who has given guarantee. So total amount, no, only to the extent of the guarantee whatever given by them. Next, in case of company limited by share capital, the liability of members is limited to the extent of unpaid share capital. To the extent of unpaid share capital. Sir, what is the difference between company limited by guarantee and limited by share capital? In case of company limited by guarantee, that guarantee amount can be called only at the time of liquidation. That too in case of deficiency. But in case of company limited by share capital, the unpaid share capital can be called by company at any time. That means even before the liquidation also. Yes. Next discussion, the different types of companies based on the number of members. based on the number of members. The first very important concept from the examination point of view is about OPC, one person company. One person company. Sir, I am a member, I am a person who want to do the business alone. Yes, you have two options. One, you can do as a sole trader. Like if you do as a sole trader, the liability of you is going to be unlimited. Now I want to do the business alone as alone, but with the features of company. Then for you having a solution given by Companies Act 2013 is forming an OPC, one person company. Please be careful guys, one person company doesn't mean one employee. One person company means one member company, one member company in which there is only one person as member, not as an employee. So one member company. Sir, what are the how it is different from the sole trader? The sole trader, the liability is unlimited, but when it comes to one person company, the members liability is limited. Next, when you start the OPC, you are going to have the features of company, and like the objective of OPC is to corporatize the business operations. And as a sole trader, you don't have separate legal entity, but once you form an OPC, the company is going to have a separate legal entity. Yes. Now let us see a few features of the OPC which are so important. As you know, only one member company. And next, what if one member dies? So that's what the one member has to appoint a person called nominee, who shall become member at the time of death or unsound or insolvency of such one member. Yes, so one member is going to be there and is going to appoint his nominee, who is going to become member at the time of his death or whatever is incapacity. Sir, how many persons can be act as members of company, members of OPC? As you know, only one member. Next, how many nominees he can appoint? You know that the answer also only one. So one nominee can be appointed. Now the question, sir, can a person can be nominee as well as nominee as well as member of an OPC? The answer is absolutely yes. If he is a member of one OPC and nominee of another OPC, imagine a case where he became the member of another OPC also, in which he is nominee. Then he became the member of two OPCs. No. In this time, within 182 days, he should take a decision in which company he want to continue as a member. He should take the decision within 182 days. Next, as you know, the person to whom you are going to appoint as a nominee, you should take his prior consent in the written form, and the same should be filed with ROC. ఇక్కడ ROC refers to Register of Companies. We have to file with ROC the declaration. Sir, next I want to change the nominee. Is it allowed or not? Answer is absolutely yes, but you have to go into intimate to ROC. No sir, the person whom you appointed as nominee, he want to resign or he want to withdraw his consent as nominee. Again the answer is yes, by giving the consent, by giving the declaration to ROC, you can change the nominee or the nominee can be withdrawn. Sir, can I appoint my kid as nominee who is a minor? The answer is absolutely no. A minor cannot be member of OPC or nominee of OPC. Now, if you want to become a member or nominee of OPC, you must to be citizen of India. And you must be the resident of India. You must be a natural person. So only a natural person who is a citizen of India and the resident of India can form OPC. Sir, once I start as a OPC, but because of increase of operations, I would like to convert into a what you call normal private company or as a public company. Can I convert it or not? The answer is absolutely yes. If you want to convert into any other type of company, at least 2 years has to be elapsed from the date of incorporation of OPC. Yes, there's a rule. No, sir, I want to change within 2 years. Not a problem. You do one thing, increase your paid up capital beyond 50 lakhs or turnover beyond 2 crores, then also it can be converted into any other type of company without waiting for 2 years. So this is what the things about OPC which is so important from examination point of view. The next discussion is about private company, which has been defined in section 2 subsection 68, which is so important. Private company is a company, just remember the 4 features, is a company first having minimum paid up share capital as prescribed by CG. Minimum paid up share capital as prescribed by CG, but remember as of now nothing has been specified. That means a private company stock can be started even with a capital of paid capital of 1 rupee also. Next, second thing, which has restricted to transfer its what you called shares. That means they can transfer shares, the members of the private company, but they can transfer only to other member, not to the public. The second condition. And third, which has been prohibited for what? To invite the public for subscription of its securities, because you being a private company, you cannot offer your shares and securities to public. You must give in to your shares and securities to the limited persons only, not to the public at large. It's a prohibition. Remember, restriction is on transfer of shares and a prohibition on inviting the public for making a public offer. Next, fourth feature, having such number of members, minimum of 2 and maximum of 200. So minimum 2 members and maximum you can have 200 members. Guys, in the calculation of this limit of 2 or 200, we shall not consider employees obviously. And what if, sir, if one share is held by 2 or more persons jointly, for the purpose of number of members, we are going to consider them as only one member. Next, if you are a private company, you have to use PVT Ltd or private limited as a suffix to your name. So these are all about private company, section 2, subsection 68. Now, let me go to the public company, which is so important, section 2, subsection 71. Public company is a company which is not a private company. Simple. So then, what are the features of public company? It should have a minimum paid up share capital as specified by CG. Again, the answer as of now nothing specified. Next, having number of members minimum 7 and maximum no limit. So as you know, the public company, there is no limit on the maximum number of members. Next, which can freely transfer their shares to any person. It can be a member or it can be a third party to third party also. That means freely transfer doesn't mean without consideration. Where there is no restriction on the transfer of shares, you can transfer the shares to any person. Next, a subsidiary company which is a subsidiary company of a public company, it should be treated as a public company only. Very important, my dear friends. There is a private company which is a subsidiary of public company, it should be treated as deemed public company only. And in the public company definition itself, public company, that means it can freely invite the public for the subscription of their securities. These are about public company.